The Atlantic Coast Pipeline, or ACP, had a planned route that would have stretched across Virginia, West Virginia, and North Carolina. And Donovan McLaurin is 73 years old. He owns a plot of land in North Carolina where he was planning to retire and build a small house. It's been in his family for 5 generations. It was right in the path of where the ACP wanted to build its pipeline. And the company tried to convince him to sell his easement, but he said no. He said, "This is America. I don't want to sell." Well, ACP took him to court, and the company got the easement from some conservative judges. President Trump, of course, calls himself the king of eminent domain. And so we're seeing this massive abuse of eminent domain power across the country. But they took his property. So he was supposed to get paid for the forcible taking, but he never got paid. They never gave any money. This year, the project taking his property was canceled after ACP failed to do whatever it needed to do under state law. That cancellation has left a huge mess behind for Mr. McLaurin and lots of other people in the same situation. ACP got easements from 2,000 property owners, including 80 people who lost their property rights through eminent domain actions based on the FERC certificate. Now, Mr. Mornoff, in other words, ACP unless ACP agrees to forfeit its easement, it continues to own access to those 2,000 parcels of land in perpetuity. Isn't that correct? Am I understanding that right?
Mr. Chairman, my understanding is that the property rights would be determined by the terms either of the eminent domain proceeding in the court or by the individual contract negotiated on a private basis. And so the terms may differ depending on terms.
Okay, and there's nothing that FERC does that conditions the receipt of an easement on the return of the property in the event that the project never goes forward. Is there anything that you do to make sure property owners get their property back if the property is taken but the project doesn't go forward?
Mr. Chairman, traditionally, the Commission has viewed eminent domain and those private negotiations to be properly addressed either in court or in those negotiations.
But you wash your hands of that. FERC basically washes its hands of that process. They say, well, that's at that point between the property owner and the company. Would you agree that an easement, by a pipeline easement, generally reduces the value of somebody's property and makes it much harder to sell? Would you agree to that? Like, to take Mr. Roy's constituents in Texas, if they didn't want to sell, but their land is taken by eminent domain, would you agree that it's much harder for them to sell their property to someone else?
Mr. Chairman, that may be the case. I think it is built into the statute that process is part of this consideration.
In fact, Mr. McLaurin had already agreed to sell part of his homestead to other buyers, and then the sales went south at the point at which the eminent domain power was exercised by the company. A U.S. district court was absolutely incredulous at what ACP had done. He said, and I'll quote just part of it here, "Here they are aggressively taking the bit in their teeth and running through several states, grabbing up land and throwing money. And on a Sunday afternoon, they decide, well, maybe we don't need all this anymore. Let's just fold up our tent." Meantime, FERC has said that it, quote, has no authority or involvement with respect to ensuring that landowners can end these easements on their land for pipelines that will never be built. So there's a perpetual indefinite easement taken on their land for projects that will not be built. Now, it seems to me there are things that FERC could do if it were concerned with actually treating landowners fairly in this process. And we understand that the pipeline companies are going to win 99% of the time. But couldn't you impose a prohibition at FERC? And I understand that you're just staff and you're speaking for yourself, but couldn't FERC include a provision in a pipeline certificate that requires it to return land back to the landowner if the pipeline gets canceled or the company changes its mind? Couldn't you put that in the certificate?
Mr. Chairman, traditionally, the Commission has viewed eminent domain and property rights as beyond its authority. That said, I do not have a case to cite that would say the Commission could not use its conditioning authority in that respect. I think that's an open question.
There's nothing in the law that stops you from doing that. And if you were interested in preserving the rights of people like Mr. McLaurin, you would say that if a company turns tail and does a U-turn, that the land should go back and they should have to restore it.